So Johnny Depp filed his appeal brief in the next stage of the Johnny Depp versus Amber Heard defamation trial. And after reading through the arguments in his brief, I really think that he should win his appeal. Let's get into it. Hey everyone, welcome to Legalbytes. If you're new here, my name is Alyte. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. So assuming you haven't been living under a rock for the last 6 months to a year, you probably know all about the Johnny Depp versus Amber Heard defamation trial. But just in case you are that one person that has been living under that rock, let's talk a little bit about just a brief background here. So Depp sued Heard for defamation over statements she made in a Washington Post op-ed implying that she was a victim of domestic violence and that in fact Depp was the one to abuse her during their marriage. After he sued her, she countersued him over some statements made by Depp's lawyer, Adam Waldman, calling Heard's DV claims a quote-unquote hoax. In the end of the jury trial, Depp won big on all of his defamation claims, and the jury awarded him $10.3 million. And on the flip side, the jury also found that Heard proved one of the statements made by Waldman was defamatory, and so awarded her $2 million as well. Heard's team immediately said she'd appeal the $10.3 million verdict, and so Depp's team responded that they would only appeal the $2 million verdict if Heard pulled the trigger first. Anyway, fast forward, and here we are with both of them appealing. As of the filming of this video, Amber Heard has yet to file her appeal brief, but Johnny Depp, on the other hand, has. And I have to say, he's got some good arguments as to why he says the Virginia Court of Appeals should reverse the judgment on Heard's counterclaims as to Waldman's statements. Now, before I get into the actual arguments and why I personally think they're persuasive, let's first talk about the statement at issue to ensure that we're on the same page here. For starters, Adam Waldman's statement appeared in an article by the Daily Mail on April 27, 2020. The article detailed ongoing litigation between Depp and the publisher for The Sun for defamation over remarks that they published regarding Amber Heard's accusations of domestic violence. Importantly, the article did include quotations not just from Johnny Depp's legal team, but also from Amber Heard's legal team as to what they say happened. Specifically, here's what the April 27th Waldman statement at issue here says. Quite simply was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. One interesting thing to note is that the other two statements, the two that the jury found were not defamatory, were similar to this one in that they labeled Amber Heard's claims as a hoax. The only real difference here was that this one was much more specific in the details as to how Waldman says it happened. And so it may have been that that specificity is what caused the jury to say that it was defamatory. But there are some real issues as to how the jury reached the verdict as to this statement. So let's turn to that part. So, okay, what does Depp's team argue as to why the verdict should be reversed as to this particular statement? Well, there are 3 errors that they say that the judge made, and they make 3 main arguments as to why these errors are reversible error, meaning that they are reason to reverse the verdict. So let's look at the errors first. First, Depp says that Judge Azcarate erred in denying his motion for summary judgment and to strike the evidence. The purpose of this motion was to strike out Heard's counterclaims as legally deficient for reasons that I'll get into in just a minute. They have to do with the core arguments of this particular brief anyway. Second, Depp says that the judge erred in denying Depp's proposed jury instructions 22, 23, and 24. These jury instructions were supposed to instruct the jury as to what an independent contractor is, the fact that an independent contractor can't be the source of vicarious liability for an agent, and that if Adam Waldman is an independent contractor, that the jury should find no liability on Heard's counterclaims. Anyway, Depp's third point is that he says Judge Azcarate erred in excluding the full Daily Mail articles containing the Waldman statements. Now, the reason why the Depp team says that these were all errors comes down to 2 main things here. First is Adam Waldman's role in working for Johnny Depp as his lawyer, and whether liability can even extend to Depp for something that Waldman did in this particular context. The second thing it comes down to is whether or not Judge Azcarate improperly cut out too much context by not including the entire Daily Mail article, or at least more of it, if not the entire thing. So let's turn to the specific arguments by the Depp team. The first main argument here is that Adam Waldman isn't an employee of Johnny Depp, but rather an independent contractor. The second main argument is that Amber Heard presented zero evidence of Waldman's actual malice, which is an essential element of defamation. And the final main argument here is that if Judge Azcarate had allowed more context of Waldman's statement to be entered into evidence by including the entire Daily Mail article, it would have been apparent that this was a statement of opinion, not of fact, and therefore not actionable for a cause of action for defamation. Now, I'll tell you right now, I personally think that the weakest of the three arguments is the third one. That said, even that one isn't a terrible argument, and I don't think that it really even should be necessary to get to that argument because the first two, in my opinion, are pretty strong. So let's dig into some of the specifics of each of these arguments to see why I personally think that Depp should win on them. So to start out, in order to talk about how Waldman being a potential independent contractor fits into this whole thing here, we first need to take a step back and understand how Amber Heard presented the issue of the Waldman statement. First, we need to talk about how Johnny Depp is being held liable for something that someone else did. This is the concept of vicarious liability. Normally, the default is that a person isn't going to be held responsible for the actions of another. In order to hold them responsible in that way, there has to be a special relationship between the two, and certain requirements have to be met within that special relationship. In this particular case, the special relationship that was alleged here was an employer-employee relationship. And that is generally accepted as one of those kinds of relationships that courts will allow for vicarious liability. As an example, if you're a truck driver for a company and you get into an accident, your company potentially may need to pay for the other vehicle's damages since you were driving in the service of the company. So in this case, Amber Heard basically asserted that Johnny Depp should be held responsible for Adam Waldman's statements about Heard, since Waldman was Depp's attorney representing Depp in the court and to the press. It is important to note that Heard did not offer any evidence that Depp endorsed, was involved in, or even knew that Waldman had made the statements at issue. In fact, Depp himself testified at trial that he only found out about them only when Heard countersued in August 2020. So it really is the case here that this is a pure theory of vicarious liability here because there's no evidence of Depp's direct involvement in these statements in any way. The problem is, because Waldman is Depp's attorney, there's a big question as to whether he's an employee or an independent contractor. This is important because the Virginia Supreme Court, like most jurisdictions in the United States, has long said that an employer cannot be held vicariously liable for the tortious conduct of an independent contractor. So before we get into why an attorney is maybe more of an independent contractor than an employee here, let's first talk about the difference between an independent contractor and an employee. Basically, although some jurisdictions like California have a unique kind of analysis on this, in most jurisdictions, the most important factor generally comes down to how much control the employer has over the worker. If you think of a normal employment 9-to-5 job, often there are a lot of rules, not just in the final product of the work, but in how the worker conducts themselves at work. What processes do they follow? What are they allowed to wear? What time are they supposed to arrive and leave for the day? Things like that. The more control is asserted over the worker, the more likely that they are an employee and not an independent contractor. In Virginia, other factors that courts will look at to figure out if a worker is an independent contractor are things like selection and engagement of the worker by the employer, payment of compensation, and the power of dismissal of the employment. But again, the most important factor here, generally speaking, is that control factor. And the reason for that is because, generally speaking, the law likes to put a relationship between the amount of control that a person has in a particular situation or over a particular individual, and that relationship between how much that the law can really hold that individual responsible for those other circumstances around them. Where someone has no real ability to impact an outcome, it doesn't make sense to hold them liable, to hold them responsible for that outcome. So now on to the question of whether Waldman fits the box of an independent contractor or an employee. An interesting thing to note here is that the Virginia Supreme Court actually hasn't looked at the issue before as to whether an attorney is an independent contractor or an employee for the client. But the majority rule among jurisdictions across the United States is that an attorney retained by a client for litigation is an independent contractor. And when I say majority of jurisdictions, we're talking DC, California, Georgia, Illinois, New Jersey, North Carolina, Texas, and more. Here are some reasons for this. First, lawyers are legal professionals who are not subject to a client's control as to how they go about providing their services. And like I said, where a client cannot control the work of a particular worker, it doesn't make sense to impute liability for actions over which they have little to no control. Second, lawyers everywhere in the United States, every single jurisdiction, are actually required to exercise independent professional judgment, and we're subject to independent professional and ethical obligations. Sometimes these obligations will go directly against what the client really wants the lawyer to do. As an example, a lawyer can't present evidence in court on behalf of a client that the lawyer reasonably believes is false, no matter how much a client tries to convince that lawyer. And the independence that is typical of an attorney-client relationship was in fact present in this case. For example, here, Waldman is a managing partner of his own firm. He also has clients other than Johnny Depp, and he offers legal services to the other clients other than Depp. So the Depp team argues the court really should align itself with the majority of jurisdictions and say, hey, look, a client can't be held vicariously liable for what an attorney does on behalf of that client. Now, I should note that this whole section is the Depp team trying to persuade the Court of Appeals. There's no binding authority in Virginia telling the court that they have to treat all attorneys as independent contractors, so it's not a given that the court will actually agree with Depp here. But to me, the arguments are persuasive. Anytime that there is a majority of jurisdictions that follow a particular rule or a particular line of reasoning, generally speaking, it seems pretty reasonable for this court to follow that as well, unless they have some kind of compelling reason to go in a different direction. And the reasoning here to me is sound. Clients generally can't tell a lawyer how to go about representing them other than hiring them for particular goals. And a client that starts to nitpick the activities of a lawyer representing them is likely to find that they are going to need to find a new lawyer. And that's because lawyers are professionals who have to and do exercise independent judgment for their representation. There are separate ethical obligations for lawyers, and it's the lawyers, not the clients, who have to pay for lapses in those judgments if they run afoul of the ethical rules. This is something that is commonly and widely regarded, and it's really not up for debate pretty much anywhere. But anyway, that's the independent contractor issue. Really, in my opinion, the Court of Appeals should consider Waldman as an independent contractor and therefore not the kind of person whose actions can extend vicarious liability to his client, in this case, Depp. But even if they did, the Depp team says that there's another fatal flaw in the evidence that Amber Heard presented in this case as to the defamation for Adam Waldman. You see, where a plaintiff is suing on a basis of vicarious liability defamation, they have to show every element of defamation as to the agent before they can extend it to the principal. And for clarity's sake, when I talk about the agent and principal, the agent here is Waldman and the principal is Johnny Depp. In other words, Amber Heard was supposed to prove that Adam Waldman checked every single box of defamation. And just in case you're a little rusty on the elements of defamation, a plaintiff has to show, first, that the defendant made a false statement about the plaintiff. Second, that the defendant made that statement to a third party. Third, that the defendant had the requisite intent. And finally, that the plaintiff suffered some kind of damages as a result. Here, because we are talking about a plaintiff that is a public figure, the requisite intent is actual malice. And again, to make sure that we're on the same page here, although you probably already know this quite well from the trial, actual malice is where the plaintiff knew that the statement that they were making was false, or that they were reckless as to the truth or falsity of the statement when they were making it. The problem here for Amber Heard is that she presented literally zero evidence that Waldman knew that what he was saying was false, or that he was being reckless as to the truth or falsity of the statement that he was making. Importantly, when Amber Heard's attorney asked Waldman during his testimony whether Waldman relied on information from Johnny Depp in making his statement, he followed the instruction of his lawyer not to answer due to the attorney-client privilege.
Then I'm going to direct your attention, Mr. Waldman, to the next statement. Quote, "Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and a publicist, and then placed a second call to 911. Do you see that statement?"
I do.
Did you make those statements?
There are two parts to what you've shown me. The first part didn't have quotation marks around it.
And I'm not asking about that. I'm sorry.
Where it said nothing could be considered credible, that's not quoting me. The part
Right.
with the quote marks, I believe I said that, yes.
So starting from quite simply through (911), you stated all that. Is that correct?
Yes, I believe so.
Okay. Did you make these statements on Mr. Depp's behalf?
Instruct the witness not to answer on the grounds of attorney-client privilege.
I accept the instruction.
Why did you make these statements?
Same instruction, same reason.
I accept the instruction.
What were you trying to convey to the press in making these statements?
Same instruction, same reason.
I accept the instruction.
Did you discuss this statement with Mr. Depp before making these statements?
Same instruction, same reason.
I accept the instruction.
Did you discuss these statements with Mr. Depp following making these statements?
Same instruction, same rationale.
Yes, I accept the instruction.
Was Mr. Depp aware either before or after that you were making these statements?
Same instruction, same reason.
I accept the instruction.
Did you make these statements with Mr. Depp's authorization or agreement?
Same instruction, same basis.
I accept the instruction.
Was Mr. Depp aware you were speaking with the press?
Same instruction, same basis.
I accept the instruction.
Did Mr. Depp ever ask you to retract or correct these statements?
Same instruction, same basis.
I accept the instruction.
If Mr. Depp had asked you to retract or correct these statements, would you have retracted or corrected them?
Same instruction, same basis.
I accept the instruction.
If Mr. Depp had told you these statements were not correct, would you have corrected or retracted them?
Same instruction, same basis.
I accept the instruction.
Did you rely upon any statements or evidence from Mr. Depp in making these statements?
Same instruction, same basis.
I accept the instruction.
This was proper because any answer would necessarily involve Waldman talking about communications he had with his client, Johnny Depp, regarding his representation of the client. And that is the very core of the attorney-client privilege. It's not something that Adam Waldman can waive because it's a privilege that is owned by the client. Only Johnny Depp can waive that, and realistically, there was no way he was going to be waiving that in this particular case. So it was proper for Waldman not to respond, and it was proper for the court not to compel him to respond. And as a matter of fact, Amber Heard's legal team didn't even try to compel Adam Waldman to answer the question after he made that objection. So with all of that said, there was no way that Amber Heard was going to get any information as to what Waldman knew or understood when making the April 27th statement. Because of that, there's a massive void where there should be evidence to support a verdict in favor of Amber Heard as to defamation with that statement, because there's absolutely zero evidence as to the actual malice element. And where there's a void, the box doesn't get checked, and a jury cannot reasonably reach a verdict concluding that Adam Waldman is liable for defamation. And under a theory of vicarious liability, if Adam Waldman isn't liable for defamation, there's no way that Johnny Depp can be either. Okay, so this brings us to the final core argument of this appeal, and it's all about context here. In this part, Depp's team argues that if the trial court had allowed them to admit all, or at the very least, more of the Daily Mail article into evidence, the context surrounding the April 27th statement that was at issue would have made it clear that it was a statement of opinion, not fact. The reason why this distinction matters is because while false statements of fact can support a claim for defamation, a statement of opinion is protected by the First Amendment and is therefore not actionable. So what's the difference between the two? A statement of fact has a provably false factual connotation or can be reasonably interpreted as stating actual, objectively verifiable facts about a person. Opinion, however, is where it's fairly clear that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise. And in order to tell the difference between a factual statement and an opinion statement, courts have to look at them in context. And this analysis has to be aimed at interpreting the statements as other people would understand them in the totality of the circumstances. Courts will consider factors like the forum where the statement was made, whether an audience familiar with the forum would expect to hear an opinion from this person, the degree to which the audience is familiar with the underlying facts, whether the statements were made in the context of a debate or controversy, whether the biases of the speaker are known to the audience, and whether the speaker claims to have any kind of personal knowledge. In this case, here's why the Depp team says that the context of the article would have shown Waldman's statements to be opinion and therefore not actionable for defamation. First, the statement was clearly made in the context of litigation. The questions asked by the reporter were about the Depp litigation against the Sun and about Heard's DV accusations, which were an embedded sort of issue within that litigation. So according to the Depp team, it's clear that Waldman's statements represent one side of this argument. Second, the Depp team says that the reporter presented quotes from both sides of the debate. This indicates that the reporter to whom Waldman spoke knew enough about the underlying facts to understand that Waldman was presenting a theory for one side of this argument. So arguably, both the reporter and the reader, both potential audiences for the statement, would have understood, arguably, according to the Depp team, that Waldman had a particular bias in favor of his client. Third, Waldman never claimed personal knowledge as to what happened on the day of the alleged hoax. And fourth, if the court had allowed into evidence not even necessarily the entire Daily Mail article, but just the other statements by Waldman from that article, the jury likely would have seen that Waldman gave reasons upon which he was basing his theory. For example, he pointed to 2 domestic abuse trained LAPD officers who provided sworn depositions saying they saw no evidence of a crime on the night that the incident occurred. Now, like I said, in my opinion, this is probably the weakest argument. Part of this is because of the fact that the standard of review for the context issue is pretty deferential to the trial court's own decision-making. But when it comes to the first 2 arguments, in my opinion, they are quite compelling. While it, of course, is always possible that the court can just 100% disagree with me, I personally agree that Waldman should be considered an independent contractor and that therefore Depp shouldn't be held responsible for any liability Waldman might have. And even if Waldman wasn't an independent contractor here, according to the court, I watched every single minute of this trial and I agree that Amber Heard presented absolutely zero evidence of Adam Waldman's actual malice. Quite honestly, we simply don't know what Adam Waldman was thinking when he made the April 27th statement because we never got answers to any of those questions at trial. So all of that is to say, in my opinion, Johnny Depp should win this appeal on this particular issue. But those are my thoughts. What do you think? Should the court reverse the trial court verdict against Depp for the April 27th Waldman statement? If so, which is the most compelling reason to you? Let us know in the comments down below. Otherwise, I hope you found this interesting or at least informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you want to see more content like this and you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next video.